Participants can communicate using the chat feature, which is available on Microsoft Teams. Maria will be monitoring the questions and comments that come in this morning, so she will pick up your feedback. Please note that time is reserved at the end of the presentation for audience questions, and we should have plenty of time for questions as we go along here. And finally, before we jump into the slides, if you have not seen Act 44 of 2023 legislation, if you scroll up to towards the top of your chat, you will see that I posted the link that will take you directly to the legislation. You're welcome to go ahead and preview that as we get started on the slides. Okay. Moving to our learning objectives for today, we hope to provide participants with a highlight of the Act 44 of 2023 legislation, discuss the probation review conference and the hearing process as outlined in Act 44, to discuss and reinforce the rights and services victims are entitled to in connection with the probation review conference. And then, as I mentioned a minute or two ago, we will hear from 3 victim witness coordinators on how the probation review conference is being implemented in their home counties. And we thought that might help provide insight for counties who are still working out a process of their own. Just as a reminder, today's training counts as 2 hours towards PCCD's annual training requirements. And just as a further reminder, according to our OVS consolidated standards, if you are an advocate that's funded under a RASA grant, a VOJO grant, or a VOCA grant, you're required to have 10 hours of training each calendar year. So today's webinar will give you 2 hours towards that 10. Participants will not receive a training certificate for today's session. But again, if any of your colleagues, staff could not attend today's training, we'll go ahead and post that on the PCCD YouTube channel. Key highlights of Act 44 of 2023. It was signed by Governor Shapiro on December 14th of last year. And what Act 44 of 2023 does is it amends Title 42, the Judiciary and Judicial Procedure of the Pennsylvania Consolidated Statutes as they pertain to probationary sentences. Act 44 specifically addresses these areas: orders of probation, conditions of probation, modification of probation, and revocation of probation. And additionally, it adds the probation review conference for qualifying defendants. Today's webinar will focus specifically on the probation review conference. Effective dates of Act 44 of 2023. So the legislation was deemed effective immediately for the sections having to do with orders of probation, conditions of probation, and then modification and revocations of probation. The probation review conference piece of the legislation became effective 180 days from December 14th, 2023, which brings us to June 11th, 2024. So defendants who are sentenced to a probationary term on or after June 11th, 2024 may qualify for a probation review conference. And here in a moment, Emily will discuss the eligibility criteria for those qualifying defendants. Okay, so the next slide is a bit of an interactive one. And just so we all know our audience a little bit better this morning, we have a poll for you that should pop up here on your team screen in a minute or two. And the question is, thinking about the county you work in, has your county instituted a process for the probation review conference? As your response, please type yes, no, or maybe in the poll. A maybe response would signify that you're not quite sure if a process has been instituted. The poll will automatically tally the responses, and please know that your responses are anonymous.
Heather, it's Maria. Would you like me to read the results of the poll?
Sure, that'd be fine. Thank
Okay.
you.
In the lead is maybe with 54%. Second is yes with 31%. And third is no with 15%.
Okay. We are getting, I'm seeing a couple chats where some participants said they had trouble submitting the poll. And then I'm seeing some chats where had they been able to submit, their response would have been a maybe. Okay. So from the responses that we did receive, and we apologize to those who couldn't submit their vote. We were trying to be crafty with teams to get that poll out to you all. But from the results of the poll, we know that many counties are still gaining an understanding of Act 44 as it relates to the probation review conference. And so with that said, we'll go ahead and get started into those discussions on how a defendant can qualify for a possible early termination of their supervision. And I will turn things over to Emily at this time.
Good morning, everyone. My name's Emily, and I'm a victim services specialist here at PCCD. Thanks, everyone, for joining us here today. So just to reiterate, Act 44 amends Title 42, which is judicial procedures. And a foundational piece of Act 44 was to create an option of what is called a probation review conference. So this review process is driven by a probation status report and is available for certain qualifying defendants to determine if they will receive an early termination of their supervision. So in order for a defendant to be considered for early termination of supervision, there are certain parameters that they must meet. So for defendants who have misdemeanor convictions, they must have been sentenced on or after June 11th of 2024. They must have served at least 12 months of supervision from their original date of sentencing and have served 2 years of supervision or upon reaching 50% of their overall probation sentence. So for defendants with felony convictions, they have to meet the same first two parameters as those defendants who have misdemeanor convictions, but they must also have at least 4 years of supervision or they must have served 50% of their overall probation sentence. So there are those defendants who are not eligible for a review conference based upon their conviction. So if a defendant has a conviction of homicide, a crime of violence, a sexual offender registration related offense, simple assault of a family or household member, or stalking, they are ineligible for a review conference. And just to elaborate a little bit, we know a crime of violence is outlined in the PA crimes codes, and it includes offenses such as, but not limited to, voluntary manslaughter, sexual assault, robbery, and arson. So Act 44 legislation permits an accelerated probation review conference, which some defendants may qualify for. So defendants must meet that initial eligibility criteria for a review conference, which I mentioned 2 slides ago. So under the accelerated review, this would make a defendant eligible for a review conference 6 months earlier than the original eligibility date. So this applies to defendants who have both misdemeanor and felony convictions. And in order to be eligible for the accelerated review, the defendant must achieve a certain benchmark, a benchmark like they have received their GED, they've obtained their high school diploma, or they've achieved any vocational or educational type degree. So each county has the discretion to determine what those designated benchmarks will be, and it has to be in accordance with the guidelines set by PCCD's County Adult Probation and Parole Advisory Committee. So for those defendants who are eligible for a probation review conference, the office that is responsible for the defendant's supervision, they have to create a probation status report. So the status report has to be filed at least 30 days prior to the defendant's eligibility date for early termination. The status report includes information on the individual's adjustment to supervision. So some of the details to be included in the report are the earliest date for review and possible termination, general adjustment to supervision, an explanation of any new charges, technical violations that have occurred within the last 6 months. And just a note on that, the legislation, the report does not have to include technical violations, which may have occurred anytime prior to the most recent 6 months. Progress in treatment or mandatory programming, how much restitution was paid, and any other pertinent information concerning the defendant's progress and adjustment to supervision. So the status report also will contain the probation officer's recommendation. So there are 3 possible recommendations the probation office can make. Terminate supervision on that eligibility date, continue the defendant on supervision as is, or continue supervision with increased or decreased conditions. So though a defendant may initially qualify for a probation review conference, there are things that may have occurred during their period of supervision that can impact the status report recommendation. So just specifically, the defendant is not eligible for an early termination of supervision if a new crime was committed under supervision. And this means any conviction of a misdemeanor 2 or higher grade, the defendant absconded from supervision, the technical violation in the past 6 months involves some threat to public safety, other technical violations in the past 6 months involving a sexual nature, assaultive or threatening behavior to another, possession, control or use of a firearm or deadly weapon, and any violations of the Controlled Substance, Drug, Device, and Cosmetic Act, or any unexcused absences from court-ordered treatment or programming, and that's defined as having missed 3 or more sessions on each a separate occasion. So once the probation status report is complete, it has to be circulated to multiple entities within 30 days prior to the defendant's eligibility date for early termination of supervision. So the following parties are to receive a copy of this status report: the defendant, the defendant's counsel of record, the court, the Commonwealth/prosecutor, and any victim registered with either the Pennsylvania Office of Victim Advocate or a county victim witness program. And I'll turn it back to you, Heather.
Okay, thanks, Emily. So once the report has been prepared and distributed, as Emily has outlined, there's a 30-day window that allows the parties of record to review the report and make any objection. At this time, the court must also schedule a hearing within the next 60 days, close to that eligibility date, and that hearing is scheduled concurrent with the distribution of the report and the review period taking place. Where no objection is made to the report contents or recommendation in that 30-day review period, and upon proper notification to each party, the probation review conference is deemed to be waived. The court will enter an order memorializing the recommendation of the probation office, and if that early termination is warranted, the order will provide the termination date of supervision. A copy of that order shall be forwarded to the victim. Okay. So let's talk for a minute about if there is an objection to the status report made by the probation office. So if an objection is made to the report contents or the recommendation by the probation officer, the court will hold that probation review conference that's already been set up. The victim shall be notified of the date and time of that review conference. Comment and input may be given on the report and recommendation either prior to the hearing or during the hearing. The victim shall receive accompaniment and any other advocacy or support services needed leading into, during, and after the hearing. And I just want to mention that Act 44 of 2023 legislation does specifically say that the local courts may adopt rules and procedures to accomplish the review conference hearings in each county. Okay. After the hearing, the court must detail its findings and forward that to the parties along with the court order. Again, the special conditions and programming may be amended. So if an early termination is not going to occur and the defendant will continue on probation supervision, that defendant is eligible for another probation review conference no later than 12 months after the current review. The process of the probation review conference, writing the report, determining eligibility, documenting the defendant's progress, making a recommendation, distributing the report, all of those things remain the same, and the victim retains the same rights that they had in the original review process. And if a second hearing needs to occur. If the defendant is continued on supervision for an enumerated technical infraction in the first probation review, the defendant is automatically entitled to a second review within 6 months from that original infraction. Again, the process will repeat. The victim retains the same rights that they had in the original process. Okay. We purposely created a slide on restitution since that is so important in ensuring that victims become whole from the crime. So under the legislation, restitution must be paid in full for an early termination to occur. In instances where supervision is not terminated solely because of failure to pay restitution in full, the court must order that the defendant be placed on administrative supervision, providing that at least 50% of the restitution was paid and the defendant has made a good faith effort towards paying restitution in full. Act 44 legislation also defines what administrative probation is to consist of, and I'll just go through that a little bit with you here just for awareness. Administrative probation is defined as having a minimum of 1 contact and a maximum of 4 contacts each year with the probation department. The defendant must keep the court apprised of any changes in address or employment. The defendant must continue to pay all costs, fines, fees, and restitution according to their approved payment schedule. Further probation supervision fees are waived once an individual moves to administrative supervision, and no other special conditions are to be imposed once the defendant is moved to that administrative supervision. But there in red, the final bullet point there, I just want to highlight that nothing in Act 44 of 2023 would prevent victims from their right to pursue civil remedies for restitution. Act 44 of 2023 legislation also recognizes other remedies also in the law. Defendants may still petition for early termination as permitted by law, separate and distinct from Act 44. The court still has discretion to alter or terminate probation supervision at any time. The court's inherent power is not diminished by the creation of Act 44 of 2023 legislation. And finally, to guide the court in the decision-making process, the court may seek additional information from the Commonwealth, the victim, the probation office, or any other pertinent entity to assist in review processes and decision-making. Okay, so Emily and I have just gone through a review of Act 44 and the Probation Review Conference. So for this slide, we thought it might be helpful to just sort of give you a visual summary of the process. So we'll just kind of go through this here again as a summary. So if you start in the top left box, the probation office receives the new probation case. They're going to make a determination whether the defendant qualifies for a probation review conference. So they're going to look at the conviction history of the defendant. And then they would mark their calendar with the earliest possible termination date if the case qualifies. What they'll do then 30 days ahead of that eligibility date is prepare the report that Emily discussed. The defendant, the defendant's counsel, the court, prosecution, and any victim registered in a county victim witness program or within the Pennsylvania Office of Victim Advocate receives that report. Simultaneously, the court shall hold a probation review conference within the next 60 days. Moving down towards the bottom, back to the left-hand side. The parties now have 30 days to review the report and the recommendation and make any objection. If no objection is made in that 30-day window, the hearing is deemed to be waived, the probation review conference is canceled, and the victim will receive notification of that cancellation along with the court order of the waiver and that earliest termination date. If there is an objection, the hearing will occur. Again, the victim has a right to accompaniment, support, and any other advocacy services that may be needed for that hearing. The victim is welcome to give input during that hearing. And then the last slide in the process, the court will make its decision and enter an order. The victim will receive a copy of that order. Okay. So at this time, I'll turn things back over to Emily, who's going to introduce our guest presenters. We'll talk a little bit about their experiences with implementation of the Probation Review Conference.
Thanks, Heather. Yeah, so like we mentioned, we thought that it would be helpful for the audience to hear from counties that have worked out a process for the implementation of the Probation Review Conference. So joining us here today, we have three advocates. We have Amber Zambrana. She is the victim advocate, one of the victim advocates for Dauphin County. Faith Euler Myers. Faith is the victim witness coordinator in York County. And Itamir Perez Pagan, who is the victim witness coordinator in Bucks County. So how we're going to do this, after each speaker, we will take some time for questions specific to that speaker. So if you have a question about one of the speaker's specific processes or topic that they brought up, please place that question into the chat while that presenter is speaking. And then once they are finished with their presentation, Maria's going to read those questions so that that specific speaker can respond to your specific question. Any other questions that weren't answered throughout the presentation, not related to the speakers, we'll talk about those at the very end of the presentation. So we are going to first start with Amber from Dauphin County. She is our first guest speaker here. Amber, if you can hear us, say hello, please. Let's see.
Okay, there we go. Now it let me unmute.
There we go. Thanks. Hi, Amber.
Hi, good morning, everyone. My name is Amber Zambrana, and like Emily mentioned, I'm an advocate for Dauphin County Victim Witness. And I'm so sorry, Emily, if you wanted me to share my video, it says that I don't have the permission, but I definitely can if it'll let me, if they want to see me.
Okay, give us 1 second here.
Yeah, no problem. Hi, okay, there I am. Okay, good morning, everyone. My name's Amber Zambrana. I'm an advocate for Dauphin County Victim Witness. I've been with the agency for, this is my 8th year, and for the past 2 years, I've been their post-disposition advocate. So I'm just here to talk a little bit about 3 things quickly: why we are implementing these procedures early in Dauphin County, how it's been going for us so far and what our procedure has looked like, and then just some unanswered questions that we have, some things that we're still figuring out that you guys might have questions about as well. So to start, the reason why we've begun implementing these procedures early is because our probation office met with our district attorney's office and one of our county judges, Judge Edward Marsico, and they determined together that they were going to rule that this be put into place in advance so that we didn't have a really big influx of cases all coming in June of next year. So they just wanted to take care of as many cases that would qualify potentially for Act 44 relief ahead of time as they could. So we've been getting these requests for, I would say, like at least a month now. We've been receiving them. And the procedure that we have is that the probation office will fill out a form. There's 2 forms that we have. They're currently using our older form, which is called an early discharge form that we're going to share with you guys. And then once June rolls around of next year, there's going to be another form that they're going to switch to. But for right now, this is the form that we're using. So this is what probation will fill out and submit to both the district attorney's office and to victim witness office. They go to myself and also to one of my supervisors, our assistant director, David Zayas. And the reason that we have them go into 2 people is just to have double the coverage because our probation office wants a response from us within 10 days of receiving this form, 10 business days. So that's a pretty quick turnaround. So with it going to two different individuals in our office, basically whoever receives the request first will try to reach out to the victim. And then if they're not able to reach them on their shift, I work nights and David works days. So we just kind of go back and forth on each shift until we're able to reach them. We try to reach out via phone at first because of the quick turnaround time. We want the victims to have as much time as possible to consider their decision and consult with whoever they need to make that decision about whether they're in support or opposed of the request. If we're not able to reach them by phone, or if we don't have a good phone number available for them, then emails are great. We've been trying to collect emails from people because that doesn't change quite as often usually as phone numbers or addresses. And our last resort is to send a letter because that's the one that takes the most time. But we certainly do that as well if we have to. If we don't have the victim's information in our system, or if their information isn't current, if their phone number is disconnected, I do a little bit of detective work. I think it's kind of fun to try to track down whatever I can. I'll use the UJS portal to try and see if I can see anything on the pre-sentencing investigation. Sometimes there's contact information on there that we didn't have, or I've called the police departments to see if they can take a peek at their report and see if there's anything that didn't make it from the report to our system. But there have been some times where, despite my best detective efforts, I just can't find any good contact information for the victim. And if that happens, I'll just indicate in number 8. Oh no, sorry, I think it's number 9. Yeah, number 9 on this form, I'll just indicate a comment that says that the victim was, that we tried to reach out to them, but they were unable to be reached for comment. And then I'll just sign it there. And in that case, when we're not able to reach the victim for comment, we, as the victim witness office, don't offer an opinion of our own because we just truly don't know how the victim will feel. Even how they felt at the time of sentencing might not be how they feel now. So we just decline to make any type of comment other than the victim was unable to be reached for comment. And we just let the district attorney's office and the probation office work together to decide what's going to happen from there. We did have one person so far that was opposed, and we're waiting for a hearing to be scheduled on that. So that's to be determined kind of how that process is going to go. But that leads me into some questions that we have that we just haven't quite worked out yet that we're still working on. And that's the last thing that I'm going to discuss with you guys today. So the first question that we had is, if the victim does object, do they have to appear in person, or are they able to submit a written statement regarding their objection? And you may know that from the parole process that you're able to submit a written objection to a parole review instead of appearing in person, or that you can sometimes even appear by video, depending upon where you live, so that you don't have to go through coming to court for that. So that's something that we're trying to determine how that process will look. And another thing that we're trying to determine is, if a victim objects, does that mean that the district attorney's office will automatically object as well, or would their opinion potentially be different than the victim's? Like, basically, how much weight would that hold with the district attorney's office? And along with that, if a victim is the only one objecting, if the district attorney's office decides to feel differently, will a hearing still occur just based on the victim's objection, even if the district attorney's office and probation are in support? Um, and yeah, I think that's all that I have for us. I really appreciate the opportunity to be here and to learn, and I've learned so much already just from the prep meetings and the training. So I just am really grateful. Thank you, everyone.
Thank you
Amber,
so
it's
much. Sorry,
hi,
Maria.
Emily. It's Maria.
Hi.
We had an earlier question, and I thought maybe you could tell us what you're doing in Dauphin County. Um, do you let victims know that this is a possibility early in the process, or is this something that they hear about for the first time when they get when you reach out to them?
Yeah, that's a great question. So I would say at this point, it is mostly that they're hearing about it when I, as the post-disposition advocate, reach out to them and tell them that this process is occurring, that the person has applied for this, or that the review is ongoing. But we have talked, we had a training recently in our office with all of our advocates, and we said that it would probably be a great thing to mention depending upon the charges of the case. You know, if you have a case that's being prosecuted and it may potentially qualify at some point for this early termination, that's something that you could discuss with the victim, like maybe at the time of sentencing, or, you know, whenever it would be appropriate to talk with them about that, just to prepare them for the possibility.
Thank you, Amber.
You're welcome.
Yeah, Amber, thank you so much. And there was just one question in the chat related to your forms, asking if the participants could have copies of those. And again, if that's okay with you, we will certainly send out these forms in our follow-up packet next week after this training concludes.
Yes,
So
absolutely.
thank you so much. If there's any other questions for Amber, of course, feel free to drop them in the chat. But as of now, we will move on to our next part, our next guest speaker, which is Faith Euler Myers. And Faith is the Victim Witness Coordinator in York County. Just make sure she can talk here. Give me 1 second. Faith, if you would like to try to unmute yourself, see if that works.
There you go. Did work.
Perfect.
Okay, so as Emily said, I'm Faith Euler Myers. I'm actually the Deputy Administrator of the Victim Witness Unit. I've been in this office for a little over 28 years. So our county actually started working with probation with early termination back in 2015. So we've had a process for quite a while. Back then, we were looking mostly at people who had done things like getting the GEDs, getting further job education, things like that, things that would most likely be factors that could potentially mean that they were not going to reoffend. So we were looking at those, restitution being paid in full, and we were doing early terms starting then. So we kind of had a process in place when this came out. We don't actually have a victim registration per se. So if we get an early termination petition, we reach out to whatever victims we have in our system. And I know there was a question earlier about whether or not this serves all victims. I'm not sure what the act says specifically on this, but we reach out to all victims, not just personal injury or anything like that. We reach out to everybody and let them know if this is going on. So now what we're doing is these petitions are coming in. Our probation office decided to start now cleaning out a lot of people who would be eligible under the act. So we're getting a lot of petitions. As a matter of fact, I had 8 on my desk this morning. The petitions are pack filed, they're printed out in our office, and they immediately come to me to distribute to my staff. So we're the first people who see them. I distribute them based on courtrooms to my coordinators in those courtrooms. We look up the victim information, we call them. If the numbers aren't good, we actually have a program called Accurate that is really beneficial for finding people. So we do our best to find people, new addresses, new phone numbers. If we call someone and leave a message, we also send a letter the same day. We try to reach out to people within 72 hours of getting the petition. So we send the letter the same day, letting them know we're trying to reach them. If we haven't heard from them within 5 days, we try to call again. And then we either hopefully got a hold of them, and then we can record their opinion for yes or no, that they're opposed or not opposed. If they, whether or not they're opposed, we let them know that if there's a hearing, if there's an opposition by either us or the victim, that they're welcome to be present at that hearing. We then pass the petition on to attorney in our office who reviews them. Our office position and our attorney's position is if the victim is opposed, we're going to be opposed on their behalf. So that most likely there will be a hearing. We're now starting to see those hearings be scheduled. And we're in the same boat where we don't know if victims will be required to attend. At this point, our office is taking the position that victims will not be required to be here, that our office will be able to represent their position, the same as we do in like a plea agreement, for instance, whether they agree or don't agree, we represent that position to the court. Our office opinion is we should be able to do the same for these hearings. I guess we'll find out when we have a few hearings how the judges feel about that. I would tell you also, when we get those petitions, we check to make sure restitution is paid, because we've had a few that have come through, and there's always a few people who try and get things through. So we've had a few come through where probation has said restitution is paid in full. It's not been, or they're making regular payments. 3 payments in the last 12 months isn't regular payments. So we make sure to verify that restitution is paid in full, or regular payments really are regular payments. So at this point, we haven't actually had a hearing, but if there's a hearing, the victims want to be present, we're obviously going to be there with them. We have a letter that we send to them when a hearing is scheduled, so that they are aware that the hearing is scheduled, and they can let us know if they wish to be here. We also let them know they have the right to speak at that hearing if they want to tell the judge why they're opposed. Once obviously it gets past the attorney, it goes to the paralegal, everything gets pack filed. I believe AOPC now has specifically things that if it's the DA's office opposed or victim opposition, so that it's specific for the petition. Our probation office is also, as far as I know, sending out the copies of the petition to victims. They have access to our PMS system, so they will send it to whatever address we have in there. So if we change the address later, they're likely not to know that. We haven't figured out exactly what we're doing about that yet, if we're notifying probation to resend or exactly what we're doing, because we haven't really run into a lot of that quite yet. So I also, just as a caveat, the restitution paid in full, I understand that in the very beginning when they were looking at making these rules, restitution being paid in full wasn't one of the conditions. It was the PDAI that fought really hard to make sure that restitution paid in full was a condition of early termination. So I think that it's just really important to know that that we really need to be on top of that. So that's basically what we do. The only thing I can say more than anything else is communication within your office is really important between the victim witness and the attorneys, to know what's going on with these cases and make sure that the attorneys have the information they need on why the victims are or are not opposed. So I think thankfully in our office, we have a really good communication. We get paralegals will send us notice of all the hearings. I get notice of all hearings. So when there's one scheduled, I get notice of it so I can pass it on to my coordinator so we can reach out immediately and notify victims. I think that's basically what we do. If there's any questions.
Maria, are there any questions in the chat? Oh, go ahead, Heather.
Faith, this is Heather Curo. I was just going to ask, you mentioned you search, it's called Accurate
Yes.
system. Okay. I've never
Yeah.
heard that. Is there a cost to that, and how does that all work?
Okay. My understanding is Accurate is kind of expensive, but our clerk's office uses Accurate, which is how they find victims and offenders when they either want to make restitution payments or, to collect. And
Right.
apparently it costs the same, doesn't matter how many users there are. So the clerk's office has given our office permission to use it. So we all have access to it. So it's like, it's kind of the thing where like a county could get Accurate and a number of offices could use it, but it's pretty thorough. You put in somebody's name and their former address, and anywhere they've ever lived pretty much pops up, their phone numbers, past and present phone numbers, and relatives pop up. You can get a lot of information on it. It's
Okay.
been very
Thank you.
successful having us find people.
Okay, thank you.
Sure.
It's Maria. There are no questions in the chat right now. Faith, you answered everything, possibly. Thank you so much.
Sure. Thank you. Appreciate the opportunity.
With
Thank
28
you.
years behind you, Faith, I guess you've had a lot of practice at this, right?
Yeah.
That's why there's no questions.
Well, I would hope that would be the reason.
Thank you so much again, Faith.
Sure.
It's Maria again. A comment from Amy in the chat. Our county detectives have an intelligence analyst. They use Accurint, ACCURINT, and we are able to send her the information to look up for us. Thank you, Amy.
All right, so moving on to our last speaker, Itzamir Perez Pagan from Bucks County. Itzamir, could you let us know if you can speak?
I think I'm good. Hi.
Awesome, thank
Yeah.
you.
And my video is showing too, so I think I'm good. Hi everybody. As they said, it's Amir Perez Pagan. I'm the Victim Witness Unit Coordinator at the District Attorney's Office in Bucks County. I wanted to address real quick the Accurate system. So I have the Accurate system. I am the one who manages it here for our office. And it is part of LexisNexis. It's I guess a page or a sub program from LexisNexis, and it is pretty expensive. So I think they do it by like licenses or something like that per office, but you can type in somebody's name and yeah, you get all the information. So just so we know, like, and you could just put somebody's name and date of birth, and it's has access to all of the United States. Anyway, just to address Accurate a little bit more. All right, so I guess I'll share a little bit about our process here at the District Attorney's Office in reference to early termination. We have had a process for a long time as well. Defendants currently, defendants are allowed to put in a motion, and they put in a motion for early termination, and then we get information from adult probation saying that this motion was put in, and then letters go out immediately. They send adult probation will send the early termination motion to our office. The district attorney who either was assigned to this case, if they're still here, or the office duty attorney. So whoever is on office duty, this district attorney for the day is the one who receives the for response, the motion for the response. And a letter goes out to the victim immediately at the same time, simultaneously of when we get the application. Then the letters that go out would just ask for their responses if they want to go in, if they want to make any comments. If we don't see response, then victim witness will call after 10 days, after 10 business days, because of the time period of the hearing. So we want to call and follow up to see, and we call all the victims in that case as well. We don't just say whatever victim that we spoke to before. So we call all the victims on the case. With this new process, it changes a little bit because of the status reviews. So from the adult probation, the letters, all the forms have changed a little than what we currently do. We haven't had a practice run the way that your county and Dauphin County are doing, because we're still doing it as if it was a motion and the information the way that the motion has been written and that process. But we have what we did immediately was we changed our disposition letter, the one that we sent out to all victims of crime, with the information about that. And we added and this is the form that Emily put up just now, we added that paragraph at the end of our disposition letter saying that because of Title 42, which is under Act 44, and we didn't want to write all that information to confuse people with numbers and acts and titles, but our district attorney felt that it was very important that Title 42 and the sub the numbers are there. So we added that last paragraph that said you should be aware that if the defendant sentence is included a term of probation that exceeds 2 years, he or she may be eligible for early termination or probation. And if they wish to provide comment, to call one of us. And those are specifically our numbers and everybody who's in our unit. We also got a early termination email just specifically for early termination, so we won't miss it. 3 people in our unit manage that email, so that way we can, if anything comes in from adult probation saying that this person was put in motion, or now with Act 42, in that email is specifically for just early termination motions and early termination process with Act 42. So that way nobody misses it. 3 of us manages that at all times, and then we can keep good timelines on that. As the process goes on, so what happens is we get an email from adult probation about the early termination motion, and one of the secretaries here at the office receives the motion. The motion then goes to either the district attorney who was specifically assigned, then from whoever was specifically assigned, if they're still here, will write back, respond and say, I have no objection, or I object to the probation. And I have that letter, but because it's an adult probation form, I did not receive permission to share it yet. There is an email out, I just haven't got response. So the district attorney gets that form. They have to respond. It is mandatory that the district attorney responds. The assistant district attorney responds within 72 hours. Simultaneously, we sent out a letter to the victim who is part of the case. And if we don't receive any responses, and then we put the information in an Excel spreadsheet that 3 of us manage, that 3 of us share, that 3 of us access at all times. And within 10 days, if we don't receive responses, we start calling the victim. And we start calling the victim. We do the three tries, you're out type thing. And then we reply in those emails to adult probation. Hey, this letter was sent on this date. This is the dates that we've tried over the phone. And as of right now, we don't have any comments from anyone, you proceed, or we do have an objection, and this is the verbal objection. They're going to be present at the hearing, or they're not going to be present at the hearing. And then hopefully that's all happens within the 30 days or before the hearing has happened. And that's our process pretty much. Are there any questions? As I was saying earlier, for phone numbers and addresses, accurate, or the LexisNexis portion of that is really, really helpful. It's true. Like, you go on to it and you just write people's names or date of births, and that really helps a lot with figuring out where the victim is currently.
It's Maria. So the letter that's on the screen right now, we can share that with people. We
Yes.
have permission to share that. Okay, great.
That's our form. This is our letter. This is the disposition letter that goes out with every single case of letting them know what happened in the case, like the outcome, the sentence. And this letter goes out to people who want to be informed, to people who have a jail sentence, to people who are receiving restitution, and to people who have no contacts. So this letter goes out. If people don't want to be informed, we don't want to force it on them, but this is the
Right.
letter that goes out to them. And then Emily, if you could put up the other form, the other letter. This one is also our form. This is our letter that is going to be used specifically for the Act 42. This is not in use yet because we probably won't be getting these cases until April of next year.
Thank you, Itzamir. We have no questions at the moment.
All right.
Thank you so
Thank you.
much.
Thanks for the opportunity.
Again, thanks to all of our speakers. We greatly appreciate your input and sharing your documentation with the field. That's really invaluable. So thank you so much. I'll just send it back to you, Heather.
Okay. Thank you, Emily. And I echo those comments of thank you to Itzamir, Amber, and Faith. We do have plenty of time if anyone has any questions or comments. I will follow up on one question that came in as we were working with our guest presenters. Faith, you had asked what the parole board might be doing and the Office of Victim Advocate might be doing in relation to the probation review conference. And since our prep sessions that we did, I reached out to Penny Hockenberry at the Office of Victim Advocate. Penny is their policy specialist. And she sent me an email late last night apologizing for the delay, but she said, yes, we have definitely worked out a process with the parole board, and she'll be sharing that with us. So one of the things that we hope to do is send out a follow-up packet to all the participants on today's call. You'll be receiving a copy of the slides that Emily and I went through. You'll be receiving the materials that the guest presenters discussed. We'll also include a copy of Act 44 of 2023 legislation. And if I'm able to connect with Penny before next week, we'll do some follow-up on what the process with OVA looks like. Maria, I'm not seeing any other questions or comments that have come in the last minute or two. Are we're good with questions?
We're
Okay.
good.
All right. If there's no further questions, again, just a reminder that today's webinar does count towards PCCD training hours. We thank again our guest speakers for joining us today and discussing the process in their home counties. And before you all sign off on today's call, we would ask participants to complete a training evaluation form. Maria just put it in the chat, so you can find it there. And we ask you to just take a minute to provide your responses and the feedback regarding today's webinar. Once you've done that, go ahead and feel free to log off. Thank you again. Have a nice weekend.